Well, good morning, Michiganders. It is Tuesday, April 30th, and this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we never send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Last day of April. That means Memorial Day is coming up. Summer's coming up. We're all starting to think about summer travel and summer vacation. It's also that time of year that Amanda and I find many people will sit back and say, you know what? I know I should get my estate plan done. I haven't gotten it done, but it's going to be pretty busy summer. I've got trips planned. I've got vacations planned. Maybe kids are going to be out of school, grandkids will be out of school. So I'm just going to wait until the fall because you need to get through summer and enjoy your summer, which is great. We all want to enjoy summer. And the one thing, if you've attended any of my seminars and I talk about that idea of waiting, there's only one promise that I ask you to make if you're going to put off your estate plan because you're too busy, and that is simply don't die or become incapacitated in the meantime, and you are golden. Well, last week's show, recap briefly. Question, do I need a will when I have a living trust? Well, you're wrong if to think that you don't need a will just because you have a living trust. And if you think that, please listen to last week's program to find out why you do need a will even when you have that living trust. Today's topic, what every estate plan must include. What every estate plan must include, but please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be specific legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. Of course, too, before we get started on today's topic, a brief reminder that Amanda and I would be honored to have the opportunity to help you protect your loved ones by either putting together an estate plan for you, amending a plan that you already have, or assisting you in settling a loved one's estate. Simply call the office today at 517-323-7366, and we'll set you up a time to personally meet with us in Lansing, or if that's not going to be convenient for you, we'll start out with a telephone call wherever you happen to be in the great state of Michigan. And as always, if it is for an initial estate planning consultation, we will make sure that you get a copy of our free estate planning guidebook. Although if you want to get a head start on that, simply head on over to doylelawpc.com where you can download a copy of the workbook from our website. And as always, there's the option for our Express Estate Plan service, and that's where you would meet with one of the many financial professionals who are located throughout the state of Michigan, who are authorized by our office to help facilitate your estate plan with our exclusive Express Estate Plan service. If that's something that might be of interest to you, ask your current financial professional if he or she is already an authorized facilitator with our office, and if they're not, suggest that they give me a call, and I'd be happy to talk to them, or shoot me an email, tom@doylelawpc.com. I'd be happy to talk to them about what it would take for them to become authorized. Or visit expressestateplans.com, that's expressestateplans.com, where we're going to give you more information about the service, and we've included a map to help you locate an authorized facilitator with contact information near you. what every estate plan must include. I've been an attorney now for, hard to believe, almost 40 years. And I think over that time, I have developed a significant amount of knowledge about estate plans, have put together thousands and thousands of estate plans between myself and Amanda, and find repeatedly that clients are not aware of what every estate plan must include. So that's why we're going to talk about that today. Now, when I said what every estate plan must include, some of you, show your hands if you want to, but some of you might have said, oh, my estate plan has to include a living trust. Or maybe it has to include a will, or maybe it has to include a power of attorney. And my answer to that is not necessarily. A living trust is not an estate plan. A will is not an estate plan, nor a powers of attorney estate plan. And I know there are many attorneys out there, you go to their seminars, and they're going to tell everybody that's in that seminar that you have to have a trust. Well, let's talk about bottom line, what every estate plan must include. And again, a living trust is a strategy. It's a tool. A living trust is not an estate plan. So let's start with what is an estate plan. Before we talk about what it has to include, what is it? Well, here's my general description of what an estate plan is. An estate plan is having made decisions about and made arrangements for three things. One, the distribution of what you own at the time of your death. Two, having medical care decisions made if you are incapacitated. And three, managing what you own if you become incapacitated. So again, an estate plan, let's break that down a little bit more. An estate plan is having made decisions about the distribution of what you own at the time of your death. It's making decisions about having medical care decisions made if you're incapacitated. It's making decisions about how you want things managed for you if you become incapacitated. And then it's making arrangements for those things. It's then making arrangements for the distribution of what you own at the time of your death. It's making arrangements for making sure medical care decisions will be made if you become incapacitated. And it's making arrangements for having what you own become managed if you are incapacitated. So that is what an estate plan is. It's making decisions and it's making arrangements. Now, we can think of an estate plan and creating an estate plan as chapters. So we're going to start with the first chapter, which I call the who chapter. Start with the who. 1. Who are you? Who are you? How old are you? What health problems do you have? What concerns do you have? Are you still working? Are you retired? Are you married? Do you have children? Who are you? Is the starting point with the who chapter. And you can always take out a piece of paper if you want to and start filling in the chapter, filling in the verses, if you will, in the chapter. Another who do you want to receive your estate if you die tomorrow? And to me, that's the best way to think about it. Don't think about if I die 5 years from now or 10 years from now or 30 years from now. Think about if you die tomorrow, who do you want to receive your estate? And then when you look at the who you want to receive your estate, ask yourself, do you have any concerns about who is going to receive your estate? Maybe they're minors, and you are concerned that they're not old enough or mature enough to receive the estate. Maybe they're incapacitated. Maybe a spouse has Alzheimer's. All kinds of things that could cause you to be concerned about who is going to receive your estate tomorrow if you die. Maybe they're a spendthrift. They can't manage money appropriately. Maybe they have a drug problem. Maybe they have some marital issues. Or maybe they're perfectly fine. They're perfectly healthy. They're mature. They're adults. Look at the who you want to receive your estate and whether you have any concerns about their abilities to receive it. Once you do that, ask yourself another question, though, that many people don't, and that is, who do you want your estate to go to if that beneficiary dies before you? So if your estate is going to go to your children, ask what happens to that child's share if he or she dies before you. Who will the estate go to then? And in many cases, who do you want your estate to go to if none of your children survive, or if none of your heirs survive, or if none of the people that you were thinking about including your estate plan survive you? So, the who chapter starts with who you are. It then goes to who do you want to receive your estate if you die tomorrow. And the third who is, who do you want to be in charge? Who do you want to have the responsibility of carrying out your estate planning wishes? And as importantly, who do you want to make medical decisions for you if you can't make them yourself? Again, the who chapter. Who are you? Who do you want to receive your estate if you die tomorrow? Who do you want to be in charge? Who do you want to make medical decisions for you? Chapter 2. This is the what chapter. And it starts with, what do you own? Make a list. What real estate do you own? What bank accounts do you own? What investments do you own? What retirement plans do you own? What life insurance do you own? What businesses do you own? What do you own? And as importantly as that, how is it owned? For example, if you have real estate, is it jointly owned? Maybe your husband and wife and your real estate is jointly owned between the two of you. Maybe you have bank accounts that are jointly owned with somebody else. Maybe you have a business that you are in business with somebody else. So not just what do you own, but how is it owned is an important piece of this chapter. And then the second part of the what chapter is, what are your estate planning goals? What do you want to accomplish with your estate plan? And there can be a number of goals that clients have. Perhaps you want to maintain control over what you own after you die. Maybe that's because who the estate is going to go to is a minor, and you want control to be maintained over that inheritance until the minor gets through college. What our estate planning goals might include the ability to change your plan as circumstances change, the flexibility to redo your estate plan as circumstances change. For some of you, an estate planning goal might be avoiding probate. You don't want your estate to go through probate. For many of you, a goal might include maintaining some family harmony. Perhaps you have seen in your lifetime the problems that some families unfortunately have when a loved one dies, and you want to have harmony maintained as best as it can be after your death. Perhaps you're in a situation where what a goal is to avoid or minimize taxes. Maybe you've got federal estate tax problems, or you've got significant money inside your retirement plans, but you've got tax issues. For many clients, a goal is going to be not to overspend. Most clients don't want to spend any more money than they have to in order to create an effective estate plan. Medicaid. Many of you out there are going to want to plan for Medicaid, or the possibility that Medicaid might be something that's going to become important to you at that point in time in the future. Perhaps charities. Maybe your goal is to do good works after you die, to look at what you have accumulated during your lifetime and to put together a process that your life's good works will continue after your death. Again, what are your estate planning goals? So it starts the what chapter. What do you own? And then it looks at what are your estate planning goals? What are you hoping to accomplish with this estate plan? And then the third chapter. The third chapter is where we, as attorneys, really become involved, and that is the how chapter. What we would call perhaps subheading as strategies and tools. What tools or strategies are available to build your estate plan? So go back. You've talked about the who. You've talked about the what. Now it's the how do you do it? And there are a lot of different strategies and tools that might or might not be appropriate in carrying out your estate planning goals. One, intestate succession, just don't do anything. Don't worry about it. The state will take care of it. The state will decide what's going to happen with your estate. Perhaps a strategy that might be appropriate is beneficiary designations, having beneficiaries on accounts, having beneficiaries on insurance policies, etc. Joint ownership is a strategy that might be appropriate. Deeds, having deeds prepared. Today's world, many times we're preparing ladybird deeds as strategies or tools for carrying out a client's wishes for their estate plan. Certainly having a will is a strategy. It's a tool. It can be an important tool. It can be a necessary tool to carry out your estate plan. A living trust. A living trust might be appropriate. It might be a revocable living trust. It might be an irrevocable trust. But having a living trust is a strategy that for many clients is going to be appropriate in order to carry out their estate planning goals. Certainly healthcare powers of attorney. If you come to a seminar, you know that I say to everybody should have a healthcare power of attorney. Everybody should also have a durable power of attorney to manage financial matters in the event that they become incapacitated. So, strategies. How are your estate planning goals going to be fulfilled? If you are concerned about wanting to manage an estate after you die, what is the best estate planning tool to accomplish that? If you don't have concerns about maturity of your children to receive an estate plan when you die, what are the best tools that are available to you to carry out that strategy? If you want to maintain family harmony, or you want to provide for charities, or whatever it happens to be when you look at that, what are your estate planning goals? The strategies are what make that all happen. So go back. What is an estate plan? It's having made decisions about and made arrangements for distributing what you own at the time of your death, making medical decisions if you're incapacitated, and managing what you own if you become incapacitated. Our job, the job that Amanda has, the job that I have in working with you then, is to, once you do that and you make those decisions, then our responsibility is to make recommendations to you and, where appropriate, to prepare documents that will carry out those recommendations. So, in answer to what does every estate plan have to include, it starts with, very simply, a plan. Every estate plan must include a plan. Well, that's it for today's show. As always, if you have a comment about the program, perhaps a topic that you'd like to have me discuss, questions that you'd like to have answered, please send me an email. That would be tom@tuesdaywithtom.com. Or you can always send me a postcard or a letter, if you prefer. Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. Please, too. Also, follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office on Facebook and Twitter, and that is Doyle Law PC. And remember, Tuesday with Tom app is available in both the App Store and Google Play, so you can take the program with you wherever you happen to be. Also available in iTunes. Simply open iTunes and search for Tuesday with Tom. You're also going to find the program available through your smart speaker that you might be using at home. Well, thanks again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.